Welcome to Trust Me, It's Complicated, the podcast where I, John Marshall, will discuss various estate planning related issues in a interesting manner, I would hope, but in a manner that is both amusing, entertaining, and educational. And I hopefully do it in a way that comes across in plain English that everyone can understand. Now, today's topic is ladybird deeds. And I'm noticing this a lot. I see it a lot online. I hear a lot of people coming in, and one of the first questions they ask me is, do I need a ladybird deed? And we're going to talk in this podcast about, first of all, what is a ladybird deed? And then secondly, when should we be using a ladybird deed and when should we not be using a ladybird deed? And I say that there are about 50-50 on when you should and shouldn't. It is a good tool, but it's not the end all be all solution that we can use to address real property. So let's start off here with what is a ladybird deed? Well, it is legally titled an enhanced life estate deed. So you understand why it's called enhanced life estate deed. Let's start with the fact of what is a life estate. Well, a life estate in real property, in homes, things like that, is the right to reside in the property for the rest of your life, coupled with the obligation to pay routine maintenance, property taxes, insurance, interest on the mortgage, things like that. Whereas another person or people own what's called the remainder interest, meaning they own the property, but they cannot sell it. They cannot evict the life tenant. They can't do anything along those lines. They basically will get full ownership rights when the life tenant has died. But neither the life tenant nor the remainder beneficiaries or the remainder owners can sell the property without the consent of the other. But the remainder owners are still obligated to pay for things like, oh, hey, the roof needs to be replaced. The entire air conditioning system has gone out, has to be replaced. So they still have a financial obligation towards the property. Oh, how about this? They have to pay the principal on the mortgage, even though they do not get to own the property until some unknown future date. So that's what a life estate is. It is person has the right to live there for the remainder of their life, coupled with some financial obligations. And then there are remainder owners who get the property at a future date, but while they're alive and while the life tenant's still there, the remainder owners still have a financial obligation towards the property. So when we use the term enhanced life estate deed, how is that life estate enhanced? Well, in the deed, it says the person who has the life estate has so much power that they can force the sale of the property and retain all the money. So, this means the remainder beneficiaries, the remainder owners listed on the deed, do not have any rights while the life tenant is alive. They also are not obligated to put any money into the property. So they don't have to pay for the roof to be replaced. They don't have to pay for the AC, nothing like that. In other words, they will own the property after the life tenant dies, but they have no financial obligation. Meanwhile, the life tenant has complete responsibility for all expenses, but can also sell the property, retain the whole thing. That is called an enhanced life estate deed. In other words, the life estate is so enhanced that you pretty much have full and complete ownership. But when you die, the life tenant dies, the property automatically vests, meaning it's automatically owned by the remainder men, the people who are listed as the beneficiaries. Let's talk about why I began using ladybird deeds back in 2009. So back in the 2000s, we were really worried about estate tax. And keep in mind that we were always doing estate plans, and the general consensus at that time is that if you have homestead property in Florida, we needed to transfer the home into the owner's trust so that we did not have to take that homestead property through the probate court. Now, well, here's the problem. Florida has some very complex homestead laws. And when I say homestead laws, I'm not talking about the reduction in property taxes if you file with the county for the homestead exemption. That is one form of homestead. But we also have other homestead laws found in our Constitution and the Florida Probate Code that we as estate planning attorneys always need to keep in the forefront of our minds. So Article 10, Section 4 of the Florida Constitution covers various aspects of homestead property. So the most notable is that other than a secured creditor and the IRS, so basically a mortgage company, the IRS, or any taxing authority. So IRS, state of Florida for property tax, and a mortgage company. Those are the only people who can come against your homestead property. If you have a car accident and they're suing you, they can't come after your homestead. If you have a big medical bill and you can't pay it, and they can't come after your homestead. Okay, so that's one aspect of it. The other aspect of it is that unless you specifically devise your homestead in your estate plan, the homestead laws say, hey, if it is going to heirs, people that would naturally inherit, whether you have an estate like a will or a trust that says who's going to inherit, or if it's just by operation of law, the homestead property remains exempt from creditor claims in death, just as it is in life. Okay. But let's talk about the pitfalls of ladybird deeds. And I think for this, let's use some real life examples that we are addressing right now. We have a situation where a lady went to another attorney and said, hey, I want a ladybird deed to my 5 kids. So the ladybird deed says from mom to, mom is life tenant with the remainder beneficiaries being these 5 kids. And it doesn't say as tenants in common. So it is presumed tenants in common. Okay. Doesn't say joint tenants with rights to survivorship. Okay. Nothing like that. So it's presumed tenants in common. And they didn't use the term per stirpes, and which is Latin, but it basically means in the bloodline. So per stirpes, let me give you an example here. Let's say I die, I have children. Or no, let's say I die, I have kids, my parents then die after me. Anything that was coming to me goes to my kids. But if I don't have kids, it goes to my siblings. Okay. So in other words, it's a way for us to say, hey, conditionally, if this person's alive, they get it. But if they're not alive, it's going to pass to their kids or to the other beneficiaries. So this deed just says mom to mom as life tenant, remainder interest to the 5 kids. By the time mom dies, one of the kids has died. One of the kids we can't find. And all in the interest of avoiding probate. Now, guess what? It vested in the 5 kids. But the one who died, we now have to probate his 1/5 ownership in the property through his probate estate. And here's the rub. It was mom's homestead property, meaning it was exempt from mom's creditors. It is not son's property. It is not exempt from son's creditors. And now we have to open up his probate estate. We probated. Now, his 2 kids own his 1/5 interest. So child 1 of mom owns 1/5, child 2 owns 1/5, child 3 owns 1/5, child 4 owns 1/5. Child 5 is deceased. His 2 kids now each own 1/10. But child 4, where are they? We don't know. Can't find them.